Thank you, ladies and gentlemen. May resume.
Judge. Just to backtrack one question, you were present for the interview of Franklin Gebhardt.
Yes, ma'am.
Can you identify him, please?
Yes, ma'am. Mr. Gebhardt is seated next to his attorney in a gray checkered style shirt with no jacket.
Thank you. No, that's all I have at this time.
Okay, you may cross.
Thank you. Special Agent Coleman, we've met.
Yes, sir.
I'm Scott Johnston. I'm representing Mr. Gebhardt. Just a few questions. Let's start out with going back to the 1983 crime scene.
Yes, sir.
You made some statements with Ms. Broder about the crime scene and it being consistent with certain, especially the markings and things being consistent with dragging, right?
Yes, sir.
Now, your statements are based on the 1983 investigation, is that correct? You weren't there.
That's correct. I wasn't even born until about 5 years later.
So your conclusions are based on the photographs and the diagrams that were done by the agents back then, is that correct?
As well as the reports, yes, sir.
Now, let's go back through that crime scene. There were quite a few things. You said you wouldn't necessarily call it a lot, but there were some things that went missing, correct?
Yes, sir.
Let's go through a few of those. One was a plaster cast of a tire impression, is that correct?
Yes, sir.
Now, part of your statement was that y'all believe that Mr. Coggins was drugged behind a vehicle, is that correct?
Yes, sir.
And a plaster cast of a tire impression could have been compared to a suspect vehicle, is that correct?
Potentially,
If
yes,
you
sir.
had one.
Potentially, yes, sir.
There are some soil samples that appeared to have blood stains, is that correct?
Yes, sir.
And you heard Larry Peterson, when he came up here, he said that that blood, some of that they assumed was the victim's because it was a large amount,
Yes, sir.
but some of those spots could have been suspect blood.
Possibly, yes, sir.
And those could have been compared to a suspect later on had they been preserved, possibly, is that correct?
Not at that time, but after, when DNA came into
Now,
testing, yes, sir.
They could have been.
Potentially. I'm not sure about degradation of DNA product or not, but I know that there are cases where they can. Yes, sir.
Okay. The wooden club, I think when Ms. Broder asked you if a weapon had been found on the scene, you kind of hesitated because there was this club or piece of wood found at the scene. Is that correct?
Yes, sir. You've referred to it time and time again as a club. I don't know if it was a club or not. It looked like it was a piece of furniture leg that was out there, but I don't know if it was a club or not.
Well, it had tape around the end. Is that correct?
I believe it did. Yes, sir.
Let's see if I can find a photograph here. I'll show you. States 18. It appears to have tape around the one end of it.
There is some tape at the bottom, well, what I'm presuming to be the bottom of the leg, sir. I think
And
it's
based on your training and experience, could that be used as an improvised club?
Yeah, I mean, anything that's long like that could be. A tree branch could be used as a club.
Okay. And that, of course, that wooden item was lost. Is that correct?
Yes, sir, it was.
There was an empty Jack Daniels bottle that was recovered
Yes,
from
sir.
the scene, and that was subsequently lost. Is that correct?
Yes, sir.
And then there was also recovered at the crime lab, there was a Caucasian head hair recovered from the sweater. Is that correct?
I believe it was from the sweater, yes, sir.
And there was a gray Caucasian head hair recovered when the jeans and sheet were processed. Is that correct?
I believe so, yes, sir.
Now, both of those items, the head hairs, could those have possibly been compared to someone later on if they had been kept?
I'm not sure how that testing works, but I believe so, but I'm not positive about how that works, sir.
But we would have had a chance, is that right?
Yes, sir.
To try it.
Yes, sir.
Okay. Let's go to the well. That well, y'all used the hydrovac process to suck the stuff out of the well, and then I think the poor guy from hydrovac Had to go down in there with a bucket and get some of the stuff.
He was a brave soul.
Okay. Now, you said to Ms. Broder there was quite a bit of what you would call trash.
Yes, sir.
in there. When you say trash, would that be kind of like household garbage, just trash?
Yes, sir. I mean, there was bread, bags for bread, plastic that was down in there. There was a burned bucket that we saw that was down there.
And some of those items were also burned, is that correct?
They were burned, yes, sir.
And you said that looking at the items, some of those items that came out, there were dates on some of the items ranging from sometime in the 70s all the way to the 2000s, is that correct?
I believe there was something that had a late 70, 78, 79 date on it, if I recall correctly.
Okay. Based on those dates and the trash and part of it being burned, based on your training experience, is it also possible that could be consistent with burning household trash in a filled-in well
I mean,
over the course of years?
The amount of burned materials that we found down there was not consistent with the trash itself being burned over a number of years. There was a very specific area or specific items that were burned within the well, but there was a significant amount of the trash that came out was not burned itself.
But you testified to Ms. Broder that area of burn or those items all got mixed up in the tank and then spewed back out onto the tarp.
Yes, sir.
Correct? So you don't know where that burned area is, whether trash was burned in 1983 or 1993, correct?
We just know what specific items were burned and what was not, but as we were going down into the well, we weren't specifically able to say, at this depth, we know this is what came out, so on and so forth.
Now, the items that came out of the well, one was this, what y'all believe was a V-neck or tank top shirt, is that correct?
Yes, sir.
And that shirt was not sent to the crime lab for any kind of testing, correct?
It was not.
And the only connection that you have to the murder is that Mr. Coggins didn't have a shirt. Is that correct? Didn't have an undershirt?
I wouldn't say that was the only connection, sir.
Well, there's no scientific trace evidence or any other type of evidence connecting that shirt to Mr. Coggins.
There's no scientific and trace evidence. However, the defects within the shirt are consistent with the crime scene.
Could they also be consistent with any other way of getting your shirt cut? With a knife?
There's numerous marks on that shirt that I can't think of any reasonable explanation for that many cuts in the pattern that they are to explain that, sir.
And you had an expert look at that?
No, sir.
The shoe that came out of the well, that shoe is a size 10, correct?
Yes, sir.
Any idea how many people in the state of Georgia wear a size 10 shoe?
I haven't polled everyone in Georgia, sir.
Probably a lot. Good many.
I reckon.
More than one, correct?
Oh, yes, sir.
Okay. Any idea how many in Griffin wear a size 10?
Again, I haven't talked to everybody in Griffin, sir.
More than one, right?
I'm sure.
And there was another piece of shoe found in that well, wasn't there?
Yes, sir.
And it was just a piece of sole, and it was a completely different type of shoe, correct?
I'm not sure, sir.
You don't recall there being a piece of sole that had kids written on the bottom of it?
Yes, sir. Yes, sir, I
So
do.
there was a piece of a completely different type of shoe.
Yes, sir, there was.
The knife that's in the well, or the pieces of knife, those were not sent to the lab to be looked at, is that correct?
That's correct.
And you heard Ms. Stewart state that y'all do have some folks that do fracture matching at the lab, is that correct?
Yes, sir.
And they may have been able to tell either if that piece of blade came out of that handle or if those two pieces of blade are from the same knife.
Potentially. When it comes to fracture matching, we do know that as time passes, that the fracture will change as it's exposed to certain things and it may not be able to be matched up.
But there was an opportunity
Yes, sir.
to test, correct?
Yes, sir.
Now, you did several search warrants, correct?
Yes, sir.
And a couple besides these that you testified to, is that correct?
Yes, sir.
One of those search warrants was for DNA from Mr. Gebhardt and Mr. Moore, is that correct?
Yes, sir,
Or
that is
two separate search warrants?
Yes, sir.
One for Mr. Gebhardt, one for Mr. Moore. And in that search warrant, you told the judge that you believed you had probable cause to believe the blood recovered from the scene might match Mr. Gebhardt, or might match Mr. Moore at the time, is that correct?
Possibly, yes, sir.
And you also did a search warrant for Mr. Charles Carey Jr.'s DNA, is that correct?
Yes, sir.
And in that search warrant, you stated you wanted to get Mr. Carey's DNA in order to compare it to a bottle recovered at the scene, is that correct?
Yes, sir.
Now, at the time you did that search warrant affidavit, March 14th of 2018, you knew that that bottle was missing, right?
We did. We were still hoping that it would be recovered as we were trying to continue to have folks try to locate evidence. We hadn't located it at that point in time, but we were hoping that we would be able to recover it.
So let's go through a few of the interviews. And I know you stated you were there for Mr. Vaughn's couple of interviews with Mr. Vaughn, is that correct?
Yes, sir. I believe I was present for 2 of them.
Okay. Well, the first one I'm looking at is April the 26th, 2017. You recall that one?
Yes, sir.
Okay. And I want to ask you, in your summary, you stated you asked Mr. Vaughn what he was looking to gain for his cooperation. Is that correct?
Yes,
You asked
sir.
him.
Yes, sir. That's generally a question with folks that are incarcerated. We will ask them, what they're trying to get out of something.
And he stated he was hoping, or was, let me make sure I get this right, he would like for you to speak with the district attorney's office regarding his sentencing, in that his time was being served consecutively rather than concurrently. Is that correct?
Yes, sir. And you also noted the following sentence that I told him that I was unable to make him any promises.
I understand. You said you're unable to make any promises, but that next sentence says that you noted you had already consulted with the district attorney's office and learned that the district attorney's office would only consider providing consideration after Vaughn had assisted in the investigation. Is that correct?
That's right. There were no deals that they were willing to offer to him.
Let's go to Mr. Vaughn's May 3rd, 2017
Yes, sir.
interview. There's just one thing that I kind of wanted to go over with you with that one.
Yes, sir.
On the second page, you gave an example to the jury of an inconsistency being, from 5 to 7 I was at home versus 5 to 7 I was somewhere else.
That's correct.
Now, in his statement to you on the 3rd, Mr. Coggins stated to you that he observed this argument across the road.
Talking about Mr. Coggins or Mr. Vaughn?
I'm sorry, Mr. Vaughn stated to you he saw this argument involving a blackmail, Ms. Guy, Mr. Gebhardt, Mr. Moore, saw this argument at approximately 10 o'clock at night.
Yes, sir.
2 days prior to finding Coggins' body. Is that correct?
Yes, sir.
And you recall his testimony, you were here for his testimony from the stand, correct?
Yes, sir.
And you recall him stating that it was sometime between 12 and 1 in the morning.
Yes, sir.
Okay. That's all I have for that. Now, you stated with Ms. Broder the interview you had with Mr. Robert Smith.
Yes, sir.
You stated that he did not give you these details initially, is that correct? About the parties on Wood Road, seeing Mr. Coggins at the parties, Mr. Coggins running away from some people and hiding in a trailer, is that correct?
That's correct, sir.
Now, when you interviewed Mr. Smith, he knew you were there looking for information on Mr. Coggins' murder, correct?
Yes, sir.
And he actually asked to speak to y'all, is that correct?
He did. He approached Investigator Tim Clift, who was then working with the Spalding County Sheriff's Office, and requested for myself and Captain Morris to conduct an interview with him.
So in an interview that he knew was about Mr. Coggins' murder, that he had requested to speak to y'all. He didn't mention seeing Mr. Coggins previously with the supposed murderer, and did not mention to you seeing the victim running away from the murderer.
No, sir, but if I recall right, myself and Captain Morris never asked him if he had seen Mr. Coggins in the past.
Okay. You recall speaking to Mr. Willard Sanders,
I do, yes, sir.
and that was back on May 10th, 2017.
Yes, sir, it was.
And you recall Mr. Moore telling you that this was this murder, that Franklin Gebhardt told him what happened. The murder occurred because of a drug deal. Moore had taken drugs, presumably cocaine, according to Sanders, and Coggins had refused to pay for the drugs.
Again, I'm just going to object to anything that wasn't testified to, just that objection defense raised to the state.
Yeah.
Let me ask you this. Mr. Sanders mentioned that Gebhardt told him that this was a drug deal gone bad. Is that correct?
Yes, sir, and during his testimony before the court, he said that he presumed that that's what it was about.
And you heard him testify that you had told him something about this being about a black man and a white woman being together. Is that correct?
Yes, sir, that was incorrect.
And you say that's incorrect?
Yes, sir.
Do you recall being present and helping with the interview with Mr. Jonathan Bennett?
Yes, sir, I do.
Now, Mr. Bennett was the young man, looked about 12.
Very young.
Do you recall him telling you that Gebhardt told him that they were driving around the trailer park, heard a woman screaming, stopped because a colored man was in the process of raping a white woman? Is that correct?
Yes, sir, that was the information he provided to us.
Let's go back to Mr. Reed. That's September of 2017, is that right?
Yes, sir.
September 22nd. And you talked about Mr. Reed had some incorrect information about the victim's penis being cut off. Is that correct? And placed in his mouth?
Yes, sir.
Okay. And he also told you that a jailer was passing information to, or had something to do with Mr. Gebhardt. Is that correct?
Yes, sir.
And that was jailer Zachary Whitmer. Is that correct?
According to Mr. Reed, yes, sir.
And you and Will Montgomery and Lieutenant Mike Morris all went to interview Mr. Whitmer. Is that correct?
Yes, sir.
And earlier, when you spoke with Ms. Broder, you stated you were not able to say one way or the other what was going on with Mr. Whitmer. I'm going to show you page 2 of your summary. If
I
you've
don't
got
have
with
it,
you.
sir.
I'll let you take a look at mine.
Yes, sir. Thank you.
In your summary, you stated that Mr. Whitmer was being truthful. Is that correct?
Yes, sir. His signs and body language indicated what appeared to be a truthful individual to us, sir.
Just a second here. I'll these papers. Now, you said that some of y'all's interviews are audio and some of them are video. Is that correct?
In this case, yes, sir. Some of them were.
And the interview with Mr. Gebhardt, could y'all have videoed that interview?
Based on the way that we were conducting the listening post operation, we were not able to get to a location that had a video recording device, which is why we audio recorded it.
Okay. Now, going back to Mr. Vaughn, just kind of one more question about him. You are the case agent on this case, so you had to kind of try to put all this case together, the old and the new. Is that correct?
That's correct, sir.
So you have gone over his 2007 interview, his 2008 interview, his 2015 interview.
Yes, sir, I have.
And then his 2017 interviews where you were finally involved. Is that correct?
That's correct.
And based on those summaries, the comment of Mr. Vaughn about seeing the young black male in the argument across the street over at the trailers with Mr. Gebhardt and Mr. Moore, that was not in his 2007 statement. Is that correct? That's not in the summaries.
That's correct, sir.
And it's not in his 2008 interview as far as the summary goes.
That's correct, sir.
And The first time we see it is in the 2015 interview with Agent Devane, is that correct?
That's correct. And again, we don't know exactly what questions were asked in 2007 or 2008 because we don't have a recording of that interview, so we don't know if that information was elicited from him or not.
But again, as far as you know, during those interviews, Mr. Vaughn knew what he was there to talk about, the murder of Mr. Coggins, correct?
Yes, sir.
And he himself had actually asked to come and speak.
Yes, sir.
Yes. Yes. Just a couple more questions. Agent Coleman, do you recall Mr. Vaughn stating that Charles Carey Jr. had somehow gotten the victim's address and that he and Vaughn had driven by where the victim had lived at sometime after the murder?
During the interviews or during his testimony?
During any of the interviews.
During any of the interviews, no, sir.
You don't recall that? You remember him saying that during the testimony?
Yes, sir, I do.
And do you recall looking through the whole file and through Ms. Coggins' testimony, Ms. Talisa Coggins stated that sometime after the murder, her family had gotten some threats, is that correct?
Yes, sir.
Yeah, I think that's all we have right now.
Can you redirect?
Briefly, were you able to determine the relationship between Charles Carey and the defendant, if there was one at all?
Yes, ma'am.
What was that?
They were very close friends.
Okay. And you interviewed Charles Carey and you got a DNA sample from him?
Yes, ma'am, we did.
And at this point, he is not on trial?
He is not.
Okay. And you haven't made any arrests with regard to Charles Carey?
No, ma'am.
Were you able to determine how long the friendship had existed between Charles Carey and the defendant?
I believe they grew up together, if I remember right.
The DNA, the blood that defense counsel refers to, where was that recovered from?
As far as what we were testing against?
Yeah, back in the 1983. Where was back in 1983? What item was that recovered from?
It was recovered from the victim's genes.
Okay. And whose DNA was it reasonably concluded that was?
The victim's blood.
Okay. So that DNA, that's the only DNA profile that they were able to obtain due to contamination, or how the clothing was packed?
Yes, ma'am, that's correct.
And that DNA went back to the victim?
Yes, ma'am.
I don't have anything else.
Just two quick questions. Agent Coleman, was there a relationship, as far as you know, between Mr. Vaughn and Mr. Charles Carey Jr.?
Yes, that was his, Mr. Vaughn is Charles Carey Jr.'s stepson.
Okay. And is there a relationship between Mr. Willard Sanders and Mr. Vaughn, as far as you know?
I can't remember, sir. I'm sorry.
That's all the question I have.
Okay,
Nothing further from this witness.
you may come down. Yes, sir.
Take rest, Your Honor. Your Honor, if we could have a short break till 1 o'clock, that's when our witnesses were told to be here, Your Honor. We also need some time to speak with our client about some of the issues that may be coming up during our
Okay, would counsel approach, please? I'm going to take about a 20-minute recess, and I think your lunch orders in the works too. The defense was originally said they wouldn't have to call witnesses here till 1 o'clock, but they're going to try to get some here early. But in their defense, they were given till 1 o'clock. We continue to move a little faster on this than anticipated. But I'll ask if you step into the jury room for about 20 minutes, extended break, and please don't discuss the case. If you testify, however, you'll be subject to cross-examination, just like any other witness that you've seen. But also, you have the constitutional right to not testify. And upon your request, if you make that election, I will instruct the jury that they're not to consider that against you for any reason. Do you understand those rights? Okay. During this break, your attorneys are going to be discussing with you whether they, using their professional experience, whether they think you should or should not testify, and that's well and good. And you should pay very close attention to any recommendations that your lawyers give you. However, this is an area where they cannot make the final decision. The final decision, regardless of their advice, is your decision and your decision alone. Do you understand that? So before this case is over, I'm going to be asking, number one, have you discussed this with enough time with your attorneys, and have you made the decision whether or not you wish to testify? And that'll have to be your decision, and I'll support your decision, whichever one it is. Do you understand that? Do you understand? Okay, good. During this break, your attorneys are first going to call some witnesses to see if we can get them here and finish up some testimony this morning. And they'll also be discussing with you whether or not they think you should testify in this case. Anything else we need to take up prior to taking a break?
Your Honor, could, I told Mr. Gebhardt, I guess, be provided somewhere a little more private.
Let me ask the court security, can they go to the holding cell here and discuss? Yes, answer is yes.
Thank you.
We can do that. Okay, we'll take a 20-minute recess. Any luck on witnesses?
Your Honor, I got in touch with Mr. Green. He said he had to change due to the court-appropriate attire.
Okay.
He's trying to make it.
Good.
But I do not have an ETA yet.
Well, let's go ahead and start the charge conference while we're waiting on that. Can you tell me the nature of the witnesses you do anticipate?
Your Honor, they're going to be a couple of the previous investigators. It's basically just going to be impeachment.
Okay, inconsistent statements.
Correct, Your Honor.
And how many do you anticipate?
I believe just two.
Just two? Any other witnesses?
No, Your Honor.
And have y'all discussed with Mr. Gebhardt whether he should testify or not?
Yes, Your Honor, I have discussed it with him, and he decided not to testify, and I told him you would be making
Okay.
that interview.
And Mr. Gebhardt, is it your decision not to testify in this case? And is that your decision?
Yes.
And have you reached that decision freely and voluntarily? Is this a free and voluntary decision of yours? Okay. All right, sir. If you change your mind, don't hesitate to get my attention and let me know. All right, sir? Okay. That being the case, I think we can start the charge conference.
Your Honor, we'll withdraw 3.30.10 alibi. I provided these and filed these before any of the evidence was submitted.
Are y'all abandoning the alibi notice?
Yes, Your Honor, I don't think that would be just.
Okay. Okay. I will charge on indictment and accusation, issuing plea of not guilty, the jury being the judges of the law and the facts, presumption of innocence. I will delete the reference to alibi. And I will charge on evidence generally. We have no depositions. Do we have any stipulations of the attorneys? We'll delete reference to stipulations. And there's been no judicial notice. I will use the long form on direct and circumstantial evidence unless otherwise requested. I will charge on credibility of witnesses, expert testimony. On the pattern charge on witnesses and how they're attacked. It says include evidence of character of untruthfulness or bias towards a party or conviction of a crime of dishonesty. Which of those do we have that might apply? Do we have any general character of untruthfulness? I don't think we do.
No, Judge.
Does the defense agree?
I'm trying to think of some good, but I can't.
Any particular evidence of bias towards a party?
Your Honor, there is the statements of several of them about the fact that they're in jail, the fact that they are hoping for some sort of.
Yeah, but that's included in the credibility charge.
And his statement says they felt threatened.
Okay.
Or did in fact he threatened them, according to Mr. Stern.
Okay. I'm a little concerned too. What about felony conviction? What offenses do we have? We have traffic in meth?
Yes, Your Honor, if you would go down the list, you have burglary from Robert Smith.
Robert Smith, possession of methamphetamine.
That's correct. Possession of methamphetamine, Robert Smith. Christopher Vaughn is child molestation. Terry Reed, we didn't.
He was in a violation of probation.
And that could have been.
The same with Patrick Douglas.
Although Patrick Douglas, we did go into his methamphetamine possession and firearm by convicted felon.
Yes.
Or possession of firearm by convicted felon.
And then trafficking for Mr. Sturgill. That's what he testified
Okay.
to, the actual
Any-
convictions for conspiracy.
Any crimes of dishonesty?
Don't believe so.
Okay. All right. And then there's a pattern charge on how a witness is supported. I'll give the general charge, but it also has a wording that says this would include character of truthfulness. We don't have any evidence of that. But it also includes a lack of bias towards a party. I think that one might apply.
I would argue that it would have, Judge.
Okay, I'll delete subparagraph A and do that. I'll charge on impeachment in general. I'll charge on prior statements of a witness. I will charge on immunity or leniency towards witnesses. Yeah, there wasn't a request on immunity.
Your Honor, I do have requests to that one.
Could I see those?
Was 131-180. It says in assessing the credibility of a witness, you may consider any possible motive in testifying. If shown in that regard, you're authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity.
That's the
leniency,
pattern
or
charge.
matters.
I'll
Pattern
cover it.
charge on that, Your Honor.
Okay. Do you have any other charges y'all are
I do, Your
requesting
Honor.
at this
There
time?
was bare suspicion, and then there's also some pattern charges on the defendant's statement.
Okay, I'll cover. I'll cover bare suspicion. I'll give immunity or leniency granted to witness. Okay, let's go to your request on statement of a defendant. This has got to be tailored, and it's not tailored on this. This is the pattern request, and it's not tailored to the circumstances because
Your Honor, I'm so sorry, Your Honor. We don't have a copy of your request.
you have a right to a copy of the request.
I apologize.
No, you should have been served copies. But the problem with that request is that the prerequisite is that he is under arrest. In actuality, according to the law, it's under arrest on these charges, and he was not under arrest on these charges at the time.
That's correct. We made the statement he was not. He was in custody on unrelated charges.
However, even if a person is not under actual lawful arrest at the time, a reasonable person in his circumstances, if it reaches a situation where a reasonable person under those circumstances consider themselves as being charged with those new offenses, even though not formally arrested thereon, that same line of reasoning applies. So I may need some help in tailoring a charge in that regard. I'm going to go through these real quickly. Bare suspicion I will cover. Immunity or leniency granted witnesses will be covered. Let's hold off on the statements of the defendants. I will define voluntariness. Burden of proof as to rights I'll address with a statement of the defendant. Again, let's hold off on conditions precedent to consideration of the statement. Credibility of the statement I will give. I will give the pattern charge on corroboration of a defendant's statement, and I will charge on no presumption of criminal intent. And I will charge on prior inconsistent statements also being considered as substantive evidence. So I think the only, with the exception of the defendant's statements, let me wade through the rest of the proposed charge. I'm assuming y'all wish to charge on the defendant's not testifying. Is that correct?
Correct.
I'll cover that. We're deleting the alibi request. I will define crime. I will define intent. I will charge on no presumption of criminal intent. I will charge on parties to a crime and failure to prosecute the principal or other persons. And in that regard, I will charge on knowledge. Statute of limitations. There's a pattern charge on that.
And we would request it, Your Honor, as regards to the last three charges in the indictment, since that was an
Okay.
issue in the case, Your Honor.
Is there a motion for directed verdict on any issue in this case?
Your Honor, we would move for directed verdict on those last three charges, Your Honor. That based on the testimony here, when you add it to the testimony from the previous motions, Your Honor, that Mr. Gebhardt was a suspect in this case from very early on, and that based on that, the statute of limitations for aggravated battery, aggravated assault, and concealing the death of another should have run, if not from 83, at least from 2005, 2007, or 2008, when Mr. Vaughn was later talked to in this case, Your Honor. The vast majority of the evidence that was presented here in court is the same evidence that the state had back in 2008 with Mr. Vaughn.
I think on this pretrial plea and bar.
That's correct, Your Honor.
I don't think there was evidence so much as there were proffers made at that time, and now the court has.
But now that there's been testimony, Your Honor, I believe we can show that Mr. Gebhardt was a suspect back then. We would renew that, Your Honor, as a motion for directed verdict, that statute of limitations has run for those three charges.
What says the state?
Now, I would argue that he was merely a person of interest up until the point where Christopher Vaughn was re-interviewed in 2017, and then the statements of those witnesses are corroborated by physical evidence that was taken out of the well, Judge. The physical evidence that was taken out of the well corroborates the statements of the witnesses. That
He was actually indicted before the well contents were unclosed.
Correct, Judge, but until the first search warrant and the knives were recovered, which was corroborated by Terry Reed's statements, I don't think he became a suspect, a real suspect, until that time, Judge.
You know, if I may, and apologies to the court, Agent Coleman did testify at the plea and bar hearing, and testified that he was not a suspect, and
not to contradict Mr. Coker, so I don't mean to do that, but he was not a suspect until he was able to corroborate some of the details set forth in Christopher Vaughn's statement. For example, going to the home, seeing the wells on the property, interviewing other witnesses, and at that point he became a suspect. The evidence presented at the plea and bar was that Mr. Gebhardt was actually interviewed, provided an alibi back in 1983, and that Mickey Guy was that alibi. And then no evidence contrary to that was presented before the court. The other thing is the issue of Christopher Vaughn coming forward.
Let me stop you there, because if Mickey Guy was credible, that would help dismiss Mr. Vaughn as a suspect at that time.
Mr. Gebhardt?
And Mr. Gebhardt, yes.
I believe back in 1983, the evidence would be that she was. They had no reason to discredit her.
But if she was credible, then that would lend credence to supporting the 807 hearsay testimony in.
It's a different, the case law, Your Honor, as far as what the plea and bar is that was Frankie Gebhardt a suspect back in 1983? No, I think it's clear that he was not. Was Mickey Guy credible to investigators? The problem is we don't know. I mean, we don't have anybody that can say that, Judge. She certainly was the defendant's girlfriend. She was present, arguably that night. The evidence that we presented was that she was present that night. Her appearance is consistent with what witnesses say was the female at the club. So that was the problem that the state had with Mickey Guy's testimony, is that since then it has become clear that there are issues with Ms. Guy. But back in 1983, none of that had come to light yet. None of that came to light, Your Honor, until Agent Coleman began investigating the case. That's why the plea and bar would fail.
That sounds like the state wants to have their cake and eat it too. She's credible for one purpose and she's not credible for the other, Your Honor. If she's credible, she's credible.
We're not arguing, I'm sorry, Mr. Johnson, I thought you were done. I'm not arguing that she was credible. I'm arguing that the case back in 1983 was closed after Mr. Gebhardt was interviewed. I mean, that's all we know, is that he was interviewed and the case was closed, if I'm not mistaken, a week later, for all intents and purposes.
What about when, in 2007, when Mr. Vaughn is again alleging things against Mr. Gebhardt?
And that came up in the plea and bar hearing, Your Honor. In the subsequent interviews with Mr. Vaughn, the issue that you have there is that Mr. Gebhardt obviously wasn't a suspect to those investigators. They didn't corroborate anything. They didn't go out and do subsequent interviews, and not until Robert Devane, Judge. And Robert Devane interviewed or attempted to interview one other person who refused to speak to him. And then Ms. Stewart testified that she did go out and attempt to find some evidence when she had the case. But up until then, Your Honor, nothing was followed up on. So the plea and bar, the reasoning behind the denial of the plea and bar would stand.
Okay. I'll withhold ruling on that issue. And I will charge on malice murder, premeditation, motive, felony murder. And as far as the felony murder goes, I will charge on the aggravated assault, which also requires me to charge on simple assault and with a weapon and those associated charges. I will charge on aggravated battery. And concealing a death. And with the exception of the defendant's statements, any other discussions or requests?
None from the state.
Okay.
None from the bench, Your Honor.
Okay, let's discuss briefly then how we're going to tailor the charge on defendant statements, because we have statements to a statement to law enforcement, which the evidence is that he was properly Mirandized.
That's for the
Okay.
jury to decide.
Okay, so y'all are not waiving the.
It's for the jury to decide if he had proper reading of his rights, if it was a freedom of voluntary statement.
Okay. I'm going to tailor these statements then to make this differentiation. I want to charge the jury, number one, that if he's not in custody on this charge, or if a reasonable person in the position of the defendant would think that he's not in custody on these charges, then Miranda is not necessary. And Miranda is not necessary in any event by one not acting as a state agent, and one who is not specifically offered a deal by the state is not a state agent. Any objection to that?
No.
I think that's the case law.
And that's to cover the statements with Mr. Vaughn?
Yes.
Yes, sir.
Okay. I will do my best to tailor it in that regard. It's going to be a convoluted, difficult charge because of the number of interviews and statements. Any other matters we need to take up on charge conference?
Nothing from the bench, Your Honor.
Okay. I think we're still waiting on Agent Green.
He's here, Your Honor.
Okay.
We could just have this moment.
Okay, why don't you go talk to him real quick?
I think we can make sure go ahead and knock that out.
Okay. Let's go do it. I do want to add an explanation. Christopher Vaughn and all the others. Does it differentiate the state? It doesn't differentiate all the other states.
Judge, you ready for Mr. Green?
Yes, sir.
Your Honor, defense will call Mr. Daniel Green.
Okay. All right.
You'll take a seat right there.
Mr. Jim, we can bring the jury in, please, sir. Good morning. Thank you, ladies and gentlemen. Mr. Green, if you would face me and raise your right hand. You do solemnly swear the testimony you're about to give in the trial of this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. You would state your name for the record.
Daniel Green.
And Mr. Green, you were previously employed with the Georgia Bureau of Investigation, is that correct?
That's correct, yes, sir.
And did you work back in 1983 with the GBI?
I did.
Do you recall being assigned and helping to investigate the murder of Mr. Timothy Cox?
Yes.
I'm going to show you what I talked to you about previously. These are, see if you recognize those and what those are.
Yes, sir. There's summaries of interviews that I did while I was working.
And is one of those summaries from an interview with Mr. Jesse Gates.
Yes, it was.
Did you know Mr. Gates back then?
I did, professionally.
Did he work for the Spalding County Sheriff's Office?
Yes, he did.
Back then?
Yes.
When you interviewed him, you've looked at your summary. If Mr. Gates had told you as part of his statement that he had observed 3 white men standing outside the club when he dropped him off, is that something you would have placed in your summary?
I don't see anything referring to 3 people.
But if he had told you that, would you have written it down?
Yes.
Okay. And you don't see anything in that summary of Mr. Gates' statement about seeing 3 white men standing at the door of the club?
No, sir.
And do you recall Mr. Gates, or Corporal Gates back then, ever giving you any information, evidence, anything about this case that he might have gathered up on his own, maybe as an independent investigation?
This is the only information that I recall having to do with Corporal Gates.
And you also have a summary there where you helped to interview Mr. Sammy Freeman, is that correct?
Yes, sir.
Okay, and you've gone over that. Do you recall ever hearing from Mr. Freeman about a telephone call from Timothy Coggins the night of this murder?
No, sir, I did not.
Do you recall Mr. Freeman ever telling you the name Frankie as
No.
a possible suspect?
No, sir.
Is that something very important that you would have placed in your summary?
Yes, sir.
Hang on just a second. Yeah, that's all. Fence asked.
Any cross?
Agent Green, is it fair to say that back in 1983, the GBI was kept at arm's length in this investigation by the sheriff's office?
We were not privileged to some information that I'm aware of now.
Do you recall if there was information sharing between the Spalding County Sheriff's Office and you and your agency at that time?
Not other than when I'm interviewing, like Corporal Gates.
Corporal Gates could have given this information to the sheriff's office, couldn't he?
Yes, he could have.
Just one brief one. When you do have the opportunity to interview somebody, you don't ever tell them to hush and don't give you all the information, do you?
No, sir.
Okay. All right. You're free to go. Thank you, sir.
And can Mr. Green be released from his?
He's excused.
Thank you.
Ladies and gentlemen, there's at least one additional defense witness who's not available until 1:30 this afternoon, so we're going to break until then. Your lunch has already been ordered and should be here any second now, so we're going to ask that you take an extended lunch break until, is it 1:30?
Yes, sir.
Or do we say 1 or 1:30?
Joe, I told him to be here at 1.
At 1, okay. So we'll try to be ready to go at 1 o'clock. And during this break, do not discuss the case with anyone nor allow anyone to discuss it with you, and don't do any type of research, electronic or otherwise. Something I want you to be considering, however, is this. Originally, I thought that you would be getting this case tomorrow morning. It looks like you're going to be getting this case this afternoon. And I don't, by telling you this, I'm not suggesting to you what speed or length of time you're going to need for your deliberations. That's an issue for you and you as collectively as a jury to decide. Whatever time you need to deliberate this case, you will take. But you will be given the opportunity. Normally we stop at 5 o'clock. But if by any chance you're close to a verdict around 5 o'clock and wish to stay later, you have that option. You just need to let us know. But it would need to be a collective agreement with the jury, with everybody willing to be staying late today. I know each of you have different responsibilities at home, and so it may not be convenient for all of you, but if it's convenient for all of y'all, and if y'all would like to stay for some later hours today, and if you're close to reaching a verdict, we certainly will accommodate you on that. However, you're not to rush judgment in your deliberations, so feel free just to break at 5, and we can finish up any time tomorrow or later that you deem appropriate. With that, y'all will be in recess until 1 o'clock this afternoon. Thank you.
Election that in 2008, this was an unsolved murder case that was being investigated by the Georgia Bureau of Investigation and the Griffin Police Department. It's my recollection that as part of that, I was actually the case agent in 2008. This case was assigned to me. I elected to go back to the beginning and tried to re-interview witnesses that were identified at the outset when this crime first happened. That was the reason I discovered Mr. Vaughn was in the state penal system and went to a correctional institution.
And the way you knew about Mr. Vaughn was that he had previously sent a letter saying that he wanted to speak to investigators about this case. Is that correct?
I think so.
When you sat down with Mr. Vaughn, did he know what y'all were wanting to talk about?
Yes.
And he knew that y'all were there to talk about anything he knew about the Timothy Coggins murder, is that correct?
That's correct.
Did you at any time tell him, don't tell me anything, or to hush?
No, sir.
That's all I have now.
Any cross?
Let's go to Beatty. After you interviewed Christopher Vaughn back in 2008, did you attempt to corroborate what he told you in that interview?
Yes.
And were you successful in doing that?
I was not.
And at that time, did you feel like you had probable cause to make an arrest in this case?
I did not.
Did you feel like you had reasonable articulable suspicion in this case?
I did not.
That's all my question.
You may come down. You're free to go. Thank you, sir.
Am I excused, Your Honor?
Yes, you are. Thank you, sir. Anything else?
Your Honor, with that, the defense would rest.
Okay. Ladies and gentlemen, there's a very short matter I must take up outside of your consideration. If you would simply step into the jury room for just a minute or two, we'll bring you right back up.